Well, good evening. My name is Travis Wisdom. I'm a PhD student in the Adelaide Law School at the University of Adelaide in South Australia. Due to the limited presentation time, I'll be presenting broad aspects of my developing PhD research, which seeks to improve the protection of intersex rights in medical procedure cases concerning intersex children in the Federal Circuit and the Family Court of Australia. Now, the option that I construct for this objective is a set of 10 best interests principles for intersex children aimed at finding solutions to these cases that combine children's rights and best interests. I'll introduce the intersex case law of the former Family Court of Australia and provide an overview of the legal framework used to resolve these cases. Then I will outline my formulation of best interests principles, first by explaining the legislative basis for these principles, followed by the sources that inspire my construction of this rights-based approach. And then I will end on identifying some of the strengths and weaknesses of this approach. Interesting. I did not think about it. Is there a way to proceed with the slides?
The clicker is not here.
The clicker is not here.
Is it underneath?
This thing right here?
Well, yeah, okay.
Fantastic.
That's forward, that's back, that's the what we get.
Wonderful. Thank you. In my thesis, I use a definition of intersex that's offered by the UN Free and Equal campaign, which is a global initiative advocating for equal rights for LGBT and I people. This definition is also endorsed by Intersex Human Rights Australia, which is Australia's largest intersex human rights organization. This definition states that intersex people are born with sex characteristics, including genitals, gonads, and chromosome patterns that do not typically fit, or that do not fit binary notions of male or female bodies. Now, I should say that I am not an intersex person, nor am I a parent of an intersex child. I came to this topic through my work with genital autonomy. I will certainly be an ally to intersex people if they will have me as one, but I'm looking at this issue from a sort of a scholarly perspective, but someone who's not part of the community. Now, the treatment of intersex children in Australia is similar to their treatment in the United States, in that they are often subjected to medically unnecessary non-consensual genital modifications, or IGM, which may include genital surgeries, removal of gonads, and hormone treatments. Now, as I will explain later, intersex cases reach the Australian judicial system if proposed procedures have or may have sterilizing effects. So it's a very small amount of these cases that actually reach the courts. Most situations involving IGM occur in environments that are difficult to trace, and as I said, only a small number of IGM cases reach the Australian judiciary. Prior to 2021, cases involving intersex children were heard in the Family Court of Australia, and this court adopted an assimilationist approach by uncritically accepting medical testimony about the necessity of interventions on intersex children, which were said to be in their best interests. The court did not adopt rights approaches in these cases. Now, the Family Court has now merged with the Federal Circuit Court of Australia to form the new Federal Circuit and Family Court of Australia. This new court has federal jurisdiction over family law matters in all of Australia except for the state of Western Australia, which has its own family court. Now, I'm unaware of an intersex case occurring in this state, so my focus is at the federal level. There's not yet been an intersex case heard in this new merged court, and there's no evidence to suggest that the new court will adopt a substantially different approach in resolving intersex cases, because the legal framework used to resolve the cases is the same. It's simply just switched to a new court. So to date, there have been 8 reported cases involving proposed medical procedures for intersex children in the former Family Court of Australia. These cases are extremely diverse. They concern minors from 18 months old to nearly 16 and a half years old, with a range of intersex variations and proposed procedures, including removal of gonads, hormone treatments, and gender affirmation surgery. Most of these minors did not have the legal capacity to consent, and in most of these cases, the court authorized the parents to consent to the proposed procedures. I imagine the majority of us here today will be most interested in the three cases that I have in bold because they relate to children too young to give legal consent, but also too young to express a view about their bodies and identities. I'm happy to discuss these cases during Q&A if interested. So cases concerning medical procedures for children reach the Australian judicial system based on principles laid down by the High Court of Australia in Marion's case. The narrow band of medical procedure cases is very diverse and concern a wide range of proposed procedures for different kinds of children. Most of these cases do not involve intersex kids. Now, Marion's case concerned the proposed sterilization of a non-intersex minor with intellectual disabilities. In this case, the majority of the High Court clarified that court authorization is required in certain situations, which acts as a procedural safeguard for children's best interests. In the majority's view, sterilization requires invasive, irreversible, and major surgery. However, other factors exist which have the combined effect of marking out the decision to authorize sterilization as a special case. Court authorization is required first because of the significant risk of making the wrong decision, either as to a child's present or future capacity to consent, or about what are the best interests of a child who cannot consent, and secondly, because the consequences of a wrong decision are particularly grave. Most interventions on intersex children occur without legal oversight, and only cases involving procedures with a sterilizing effect reach the court. However, the majority of the High Court of Australia made it very clear in this case that sterilization as a byproduct of an intervention intended to treat a malfunction or disease does not require authorization. Now, embedded within these principles is a very wide discretionary power for the Federal Circuit and Family Court of Australia to determine whether a procedure requires court authorization. So after the court determines whether authorization is required, the court must determine whether the proposed procedure is in the best interests of a specific child. The Family Law Act is the principal act of Division 1 of the Federal Circuit and Family Court, which deals with specialized family law matters. The court resolves medical procedure cases under Part 7 of the Act, which relates to children. In deciding whether to make a parenting or welfare order in relation to a child, the court must regard the best interests of the child as the paramount consideration. The court determines best interests based on two tiers of factors known in the legislation as primary and additional considerations. The two primary considerations are the need to protect children from physical or psychological harm resulting from abuse, neglect, or family violence, and the child's benefit of having a meaningful relationship with both parents. Now, the additional considerations tier is much more extensive, which features 14 factors that can be grouped into the 9 broad and interrelated issues that I have on the screen right now. Some of these considerations are relevant to intersex cases. Some may only be relevant to a very specific intersex case. Others may be totally irrelevant. It's unnecessary to detail the 14 factors today, but what's important to bear in mind here is that the best interests test must be used in all cases under Part 7 of the Act, where the court must regard children's best interests as the paramount consideration. So to look at this legal framework broadly, the principles elucidated by the High Court in Marion's case are applicable to all medical procedure cases, whereas the best interests test in the Family Law Act is much broader so as to apply to all cases requiring the paramountcy of children's best interests. These are the principles that the court must apply when resolving intersex cases, which are diverse in nature and can be very complex. But these principles lack specific guidance on intersex children as such and the unique impact that IGM may have on this specific group of children. These principles also promote a best interests approach. The best interests test in the Act does not explicitly promote or prohibit the consideration of children's rights when determining what is in a child's best interests. Now, requiring court oversight for all forms of IGM, or I assume everyone here would agree, all forms of GM, would require legislative change, and the Australian government has indicated that it does not support amending the Family Law Act to expand the role of the court. which makes my job a little bit harder because I have to work within these legislative constraints. So in order to function within them, in my thesis I construct and test a human rights-based framework of 10 interrelated best interests principles to assist the Federal Circuit and Family Court of Australia to find solutions to intersex cases that combine rights and best interests. The idea here is to enable children's rights to inform their best interests in a legal setting. So there is a legislative basis on which the court can refer to my formulation of best interests principles. In 1997, the full court, meaning more than one judge, of the former Family Court of Australia interpreted the relevance of the UN Convention on the Rights of the Child, or the CROC, to the Family Law Act. The Act states that when a court exercises jurisdiction under the Family Law Act, it must have regard to the need to protect children's rights and to promote their welfare. In the full court's view, the starting point of this consideration is the UN Convention on the Rights of the Child, to which Australia is a party. And I'm sad to say that the United States is the last country on earth that has not yet signed on to the convention. The full court has also indicated that the CROC is an origin to Part 7 of the Act, which again relates to children. It is under Part 7 of the Act that the Federal Circuit and Family Court resolves these cases. Therefore, the CROC informed the drafting of Part 7, and the CROC is relevant to the consideration of children's rights under the Act. Now finally, and very importantly, according to the full court, a primary section in any consideration under Part 7 is the Objects Clause, which outlines the aims or the purpose of Part 7. Now, in 2011, the full court's views gained parliamentary legitimacy when the Family Law Act was amended to provide that a further object of Part 7 is to give effect to the CROC. This is as close as we get to implementing the Convention on the Rights of the Child in Australian family law. So the Parliament has essentially opened the door, kind of waved, looked inside, and without actually going in and full implementation, this is as close as we can get. It gives effect to the treaty. Now, this provision provides a legislative green light to use the CROC as an interpretive aid when resolving intersex cases. So therefore, as my best interests principles function as a rights-based framework, the court can refer to the CROC as an aid to interpreting and applying my principles. As I stated previously, the court must determine children's best interests based on the primary and additional considerations outlined in the Family Law Act. One of the factors listed as an additional consideration allows the court to consider any other fact or circumstance that the court thinks is relevant. This is particularly useful for my purposes. This provision allows the court to have regard to human rights or to utilize my formulation of best interests principles in intersex cases. So my development of best interests principles inform the court's determination of best interests within the meaning of the Act. So I'm not expanding the definition of best interests. I'm still abiding by legislative constraints. And they provide professional guidance on issues impacting intersex children and the adults that they become. My starting point to developing these principles is a set of ethical principles proposed by Lynn Gillum, Jacqueline Hewitt, and Gary Warren of the Australian Royal Children's Hospital. The Gillum, Hewitt, and Warren approach is a good foundation intended for a medical setting, but it is ultimately inconsistent with children's rights because it endorses IGM. However, these principles unfortunately remain relevant to a judicial context because they have been endorsed by Australian medical and governmental bodies. So for my purposes, I reimagine their principles to make them relevant to a legal setting, having regard to rights-informed views expressed by the German Ethics Council and the Swiss National Advisory Commission on Biomedical Ethics. The views of these bodies are informed by human rights and to some extent by voices of intersex people, both of which are lacking from the Gillum, Hewitt, and Warren approach. And finally, I incorporate views of Intersex Human Rights Australia, Australia's leading intersex rights organization, which ensures that intersex voices inform my principles. So I'm cognizant that as someone who's not part of the community, they need to be part of everything that I do. So as the adage goes, nothing about us without us, or nothing about them without them. So the 10 principles I have formulated based on these sources are not listed in any hierarchical order. They are interrelated, and the relevance of each principle depends on the facts of a particular case. They're intended to be flexible so that they can apply to as much of the case law as possible. So principle 1 is to avoid unnecessary medicalization of children's variations of sex characteristics, which aims to prevent pathologizing intersex bodies. It emphasizes that while some intersex variations require medical treatment, some do not, as often is the case. Therefore, medical intervention should not assume crisis indifference nor normalization as the goal. Principle 2 is to minimize physical and psychosocial risks to the child, which emphasizes that the benefits and risks of intervention must be ventilated and considered, including the lifelong ethical, sexual, and human rights implications. Court authorization of intervention should not be based on medically unnecessary reasons. Principle 3 promotes the preservation of the potential for the child's fertility. It emphasizes that medical intervention should aim to promote fertility even if it does not match the assigned gender or preserve the ability to produce hormones. Principle 4 aims to preserve or promote the capacity to have satisfying sexual relations in the future. It cautions that the promotion of such capacity by surgical or medical means is but one factor in the broader determination of a child's best interests. Promotion of such capacity also considers that the child may have satisfying sexual relations in the future without surgical intervention. And the capacity to have satisfying sexual relations also includes a person's mental health and well-being, and includes consideration of how medical intervention may promote or hinder such capacity for the future adult psychologically. Principle 5 promotes leaving options open for the future, including the potential for different life paths and identities. This principle is broad so as to include intersex people who are LGBT or intersex people whose genitalia do not traditionally conform to the person's identity. Leaving options open for the future is a means to protect a child's physical and mental integrity, which is Principle 6. Physical and mental integrity safeguards the inviolability and intactness of the body, thus preserving bodily autonomy, and protects individuals from bodily harm, non-consensual interferences, and psychological suffering. Principle 7 ensures that the court expressly consider the efficacy of all alternatives to a proposed medical procedure in an intersex case. Now, depending on the facts of a specific case, alternatives to a procedure can include no intervention, obviously, non-surgical monitoring for developing health conditions, or surgical repositioning of gonads to a different location in the body. Principle 7 also promotes the consideration of affirming counseling and peer support, which can replace or be used in conjunction with medically necessary interventions. Of course, an important alternative to a proposed procedure is to delay non-urgent interventions until the child can participate in decision-making, which is Principle 8. Principle 9 promotes the consideration of children's views in accordance with their age and maturity. It respects the views of children who have the legal capacity to consent, but also aims to give weight to children's views who have the capacity to express a view even though they've not yet reached the elevated threshold to provide legal consent. And finally, Principle 10 expressly considers family and cultural contexts having regard to human rights, and in such a manner where these contexts yield to the paramountcy of children's best interests. Maintaining the paramountcy of children's best interests ensures that Principle 10 is consistent with the requirements of the Family Law Act, and consideration of family and cultural contexts is also consistent with a very strong focus contained in the Act within the meaning of the best interests test. So I imagine most of us would like there to be less of an emphasis on this aspect, but we have to work with what we've got in the Family Law Act. That still is a very strong aspect of it. So if by creating a principle that recognizes the importance of these contexts, but yields to the paramountcy as required by the Act, I think is a way to kind of finagle around the intricacies of the legislation. So, as I previously said, this research is still developing, and I'm currently testing the efficacy of these principles in the case law of the former Family Court of Australia. My development of these principles has strengths and weaknesses as a rights-based approach. First, these principles may increase human rights uptake in intersex cases by guiding the court to consider children's rights, which is currently absent in this body of case law. They serve as an educative function for courts and medical professionals by framing IGM in terms of the rights of the child, which may over time impact how medics describe IGM in their testimony in future intersex cases. These principles also encourage, or should encourage at least, a nuanced judicial approach to interacting with evidence rather than serving as a rubber stamp for medical views expressed in intersex cases. However, these principles may not produce solutions to intersex cases that combine rights and best interests. There is discretion in whether the court chooses to adopt these principles, and there is discretion in the court's interpretation of these principles. So the court can decide not to use them at all, or the court can say, we'll entertain this idea and adopt these principles, but we're going to interpret them in a different way. And in so doing, they may not replace or undermine the assimilationist approach that the former family court adopted in intersex cases, which is likely to continue in future cases in the new Federal Circuit and Family Court of Australia. Notwithstanding these weaknesses, my development of best interests principles for intersex children is but one option to direct the court's attention to the growing global human rights legal concerns surrounding medically unnecessary, non-consensual interventions on intersex children, a presence which may become difficult to overlook in the development of future case law. And I'd like to extend a very special thank you to Attorneys for the Rights of the Child. Without the organization, I would not be here today. They have generously supported my ability to attend. And also to Vinci Chen, who is my leader at my employer in Las Vegas, which I know has nothing to do with Australia. That's a topic for a different day, who has supported my professional endeavors over the last couple of years and graciously allowed me to take the time off to be here today. So thank you.
I understand, but I'm racking my brain. I can't remember where I've heard that they're backing off on intersex surgeries in the U.S. That when not medically necessary. Do you know anything? Does anybody know anything about that? Did I hear that right?
I do know that recently there was one hospital, I want to say in Boston, that pledged they're not going to be doing those intersex surgeries anymore.
Lurie Children's Hospital in Chicago, and then also Boston Children's Hospital said they would limit their surgeries.
Key word there, limit.
Yeah, limit, yeah. But basically, the interesting thing about Lurie Children's Hospital is they formally apologized to the intersex community in writing for perpetuating these surgeries all these years.
Good step forward.
Thanks. Travis, I had a question about how those cases come to the court. Is it because there's a disagreement between two parents about how the child's future should play out? Or is it medical people dragging the family into court for some sort of adjudication?
It's the medical professionals who are dragging the families into court. So anytime that there is a procedure that has a sterilizing effect or may have a sterilizing effect, it goes to court based on those principles elucidated in Marion's case. So most of those cases involve the removal of gonads. That's the reason why those immediately go to court, and then the family court will decide if it's in their best interests. If there is a disagreement between family members or the doctors and the family, those would go to court. That hasn't yet existed. The existing case law does not demonstrate that there's any disagreement. They go to court because of that concern of, sterilization. Thank you.
Thank you.
I have a question. Thanks. Travis, I had a question about how those cases come to the court. Is it because there's a disagreement between family members or the doctors and the family? Those would go to court. That hasn't yet existed. The existing case law does not demonstrate that there's any disagreement. They go to court because of that concern of, sterilization. Thanks so much, Travis, and it's lovely to see you after so long.
Great to see you.
I'm wondering if you can dig a little bit deeper into that controversial criteria that you had in there about taking the culture into consideration. If you could put a little bit more meat on those bones, like what would it look like to take families' cultural preferences or religious preferences into consideration? Just give us something a little more concrete.
Sure. So this hasn't yet occurred in an intersex case. I imagine this would arise in a case involving Indigenous Australians, if they have an intersex child and perhaps there's a cultural or religious reason to alter the child's body. The court would then be faced with having to weigh the moral weight of the indigeneity of the parents and how that would impact the child, how it would impact the child if they allow the procedure to occur versus if they were to block it. Would that have any sort of detrimental impact on the child to their right to enjoyment of their culture? I imagine that if the case didn't involve Indigenous Australians, it would be a little bit easier for the court to weigh the cultural and religious aspects. And the reason for that is that there are specific criteria when interacting with Indigenous Australians in the Family Law Act and throughout the case law. So that presents a whole body of other complexity. The Gillum, Hewitt, and Warren approach offered my principle 10, where it said that we should respect parents' wishes and views. And I expanded on that concept because I don't think that they should necessarily be respected. We can consider them and we can weigh them as one aspect or one element in this broader determination of what's in the best interests of a specific child. I don't think it should necessarily be disregarded, but the paramountcy of best interests should remain as required by the Act. But I also think that all of this needs to yield to consideration of children's rights. And what's different with Australia than here is that Australia has international obligations to fulfill based on their agreement to the UN Convention on the Rights of the Child. Now, whether they do that or not is a very different issue, but they do have these international obligations. So I think that there's been some interesting transgender cases in the former Family Court of Australia. Some of them will briefly talk about the cultural contexts of the trans children, but because the court sort of just glosses over it as it does in those cases, I'm inclined to think that they weren't Indigenous. They may, and I'm also inclined to think that they may come from European countries because they don't really deal with any sort of otherness with this particular family dealing with these issues. But on the intersex side, that has not yet occurred. Mm-hmm.
I think we have time for one more question or two more. Okay, good.
Hi there. So I saw your use of variations in sexual characteristics briefly mentioned in there, and I like that because I've been thinking about the terminology. I've been involved with intactivism for 15 years since I was in high school, and I remember hearing male, female, intersex, as if they were three completely separate categories. I have heard use of language like differences in sexual development, variations in sexual characteristics, and I came to the realization that unnecessary surgeries have happened because of sexist ideas of what males and females should look like.
Absolutely.
And this is especially true for males and females who have differences in their sexual development, and possibly it's that we're so sexist as a culture that we can't even accept them as the sex they are. And so it's a very different aspect that I realized over time, and I'm just putting it out there. For example, if a boy with a small penis or different testicles or something, we're so sexist that we can't accept him as a boy, and we call him intersex or something, or we call him something separate, and then he might be castrated and called a girl, assigned a girl or something. So I think that the larger issue here is sexism and our ability to not be accepting of that variation within the sexes. But that's just, have you heard variations of sexual characteristics, differences in, I've heard disorders of sexual development too, but I know there's a lot of controversy around that too because of pathologizing. But,
Absolutely.
you know, when I brought up differences of sexual development, someone was like, well, you know, clubfoot isn't a difference, it's a disorder, you know, disorder. So, I mean, like, I'm trying to sort out all the language, but if you have anything else too.
You know, I think what has been rewarding about this entire journey with living in Australia and interacting with intersex people is, from an outsider's perspective, I'm trying to learn what they go through and how I can incorporate that into my work to better advocate for every child. And I certainly don't get it right a lot of the time, and so I learn from intersex people with the type of language that they would prefer. Based on my interactions, it seems that intersex is the preferred term, but there are intersex people who will say that they have a DSD, a disorder of sex development. They may change it to differences in sex development. Some identify as a hermaphrodite, and if that's what the word they want to use, I think that they have that power and should be respected.
I've heard that as well. Yeah.
I avoid using differences in sex development because I think it's too close to disorder. But some of the court cases, or one in particular, did involve an intersex variation that clearly was a disorder. That there were serious medical conditions associated with that particular variation. So from my perspective, I wouldn't see it to be problematic to refer to some intersex variations as a disorder, but to be, I guess, easily understood, I just say intersex, and I follow along with what intersex people are telling us. How do these words impact them and their lives? And that's also been very interesting as kind of an intactivist going into this space where there's a lot of tension between the intersex rights movement and the genital autonomy movement, and trying to build a coalition. It certainly is not easy, but I think that if we remain sensitive to their needs, and we're very cognizant of working with them and writing with them as opposed to about them, that will help to bring some of those bridges together. I can't speak of what it's like in the U.S. because I started the work on intersex issues in Australia, so I only have an Australian perspective. There certainly is tension there. There's a concern of that we as intactivists co-opt the movement. Part of that is with the language that we use, and so by changing my framework to say sex characteristics as opposed to sex or gender, that's been a way to recognize some of their views and implement them in my own work.
Thank you.
That's it. Okay. Thank you.
Okay. Absolutely.